It's continued motion regarding request for school change. The plaintiff is in the courtroom represented by attorney Brian H. Gene. Mr. Van Valkenburg, defendant is in the courtroom represented by attorney Dennis Reed. The court previously at hearing had the opportunity after hearing by stipulation of parties to meet with the minor child. In this case, the court had the opportunity to meet with the minor child, and maybe I say this too often, but I mean what I say, that you have a bright young child. Really bright child. And this child, I think, is going to go a long way. So it's a great meeting, and not going to go into what the child discussed, but suffice it to say the court had learned some valuable information that was productive as to both. That's where I'll leave it. Mr. Reed, since this is your client's motion.
Yes, it is, Judge.
Is there anything further you wish to add?
Your Honor, as the court's aware, I just was retained on this matter the other day. And, I have privately, but I'll say it here in court, I think it was one of the best over motions that I've ever seen filed in a matter like this. It's very professionally done. I think you get all the high notes that are necessary on a motion like this. I think his rationale for doing what he wants the court to do is there. We live in a very mobile society. Mother is a living example of that. She lives 6 times in 8 years. She's chosen to live in Flint this time. But every year and a half or so, she relocates for whatever the reasons are. My client is asking to move the child's school district, the next competing school district. Croslex, Parsonville, Fort Sanilac, both are fine schools. Sanilac County, which the parties both agreed to, so we're not suggesting the child will move out of the area or out of the state. Client has purchased a home, stable. He's maintained a home for his child throughout the course of this since they were center. It's a very good household, loving family, and I think that would do well. Croslex said he's indicated he's a very nice young man, very social and intelligent. I think it would do well, just as well in Croslex or in Parsonville, Fort Sanilac, as it is in Croslex. Certainly, kids never like to leave schools. It seems like, and that's a common problem with kids, but parents move for various reasons. My client has laid out his reasons of motion. I think they're very rational, very good. He's not trying to interfere with mother's relationship with his child, at all. And she's the one that actually has extended the mileage. If we're going to look at that, it's how far she might have to drive to the Parsonville area rather than the Croslex area. She lived in Tarrant County, I understand, at various times, and chose to move to Flint. That's just the way it is. And yet she anticipates my client is going to continue ingrained in Croslex because she wants it that way. So, Judge, I don't think that's the purpose of this. The purpose is to move rational, it's logical. I guess at the end of the day, it's in the best interest. It's not harmful to the child to move one district over, but it just isn't. There's nothing extra special about Croslex compared to Parsonville or Sanilac. Croslex has certainly the college program down there, but we're talking about a 13-year-old child here. He's not going into that program at this point in time. Parsonville, Fort Sanilac is a very good school. There's a very good student-to-teacher ratio, and I think he will thrive there as well. So I asked the court to approve his request. He's made in his motion.
Thank you, Your Honor. A few responses, and I'll try to keep it as brief as I can. First off, to suggest that this motion has no intention of interfering with my client's parenting time is patently false. There's a request here to reduce her parenting time and modify it such that Mr. has almost all the time, particularly during the week. So when we talk about whether or not this would interfere, I think that it absolutely would. My client is not asking for a modification of the parenting time schedule at this point. I don't believe that would be appropriate. There's been no indication that she has not been able to get the child to and from school. There's been no indication that her drive has been problematic. it's been happening that way for quite some time. Even prior to her recent move, she was driving virtually the same amount of time, and that never seemed to be a problem before either. And then secondly, to suggest that it's not harmful to move this child is, again, I think false. Any child, particularly a 13-year-old that has established relationships in the school district, friends, with teachers, etc., it certainly would be harmful to move a child, even if it is just one district over. We believe that that it would not be in the child's best interest to modify the school at this time, nor to modify the parenting time. And so we are asking the court to simply deny the motion outright. Thank you.
Thank you. I will pose this question to both counsels. Obviously, that was speaking to the client regarding
Yeah, I don't think so, Judge. If the child would have to be transported to some location outside school district, get the bus, and I have to cross over the line. So
I get that, but is there a bus stop? That's my question.
Your Honor, my client has indicated that she did look into that, the closest one.
I wouldn't know the answer to that either.
The closest one to Mr. would be 8 minutes.
5 miles, 8 minutes.
8 minutes from his home for that bus stop. My client takes the child directly to and from school, so for her it's not an issue.
I need to know that answer. I'd like to know that answer. So I don't need counsel to come back to argue unless you wish to, but I do need to know that answer. And once the court knows that answer, I can give you an opinion, or if you have the answer and you want to notice it, then the court can make a decision.
Your Honor, my client has indicated that that bus stop is located Hoverson and Lakeshore.
It's located where again?
Hoverson and Lakeshore.
I'm assuming Lake Shore's 25.
Judge, my client informs me that he believes there is a bus stop about 10 minutes away, but with his work schedule, he's not going to be able to arrange meeting the bus, waiting for the bus, both pick up and deliver. She's talking about both ways to school here. So that would be getting home, 3:30 or so, and getting the bus stop, I don't know, 7:30, 8 o'clock.
Or does he also take other children?
There is, there are specially arranged buses for one child that's yes. The county has arranged buses for that child.
So there is a bus stop 10 minutes away.
But the timing is such that I don't know how to do it.
I don't need to. I don't need to wait.
I find it.
If you have anything else.
Just in response to Mr. Potentially being unable to take the child, my client certainly has no issue taking the child every day. If she had the child primarily, point being is my client.
Well, that's not the motion.
Yeah,
I agree. It's simply that my client will make necessary arrangements for the child.
and just, I mean, it's not just taking the child, waiting, and then being there to pick up the child later in the day. It's going to be a part-time job for whoever's going to do it.
How's it been so far? The child was going.
The bus came to residence, but that's in the process of system. The bus route came right to the front door, right?
All right, well, the motion understandably is because there was a move to the CPS school district versus the first. And there are two other children. Not of the parties here, but that fathers involved with, and it only makes common sense to file this motion requesting that the child will be moved. We already discussed the issue of mother moving to another location area, which is still well, I would say well below, but my calculation indicates 60 miles as a program. So that issue has been resolved. But as to this motion, the court had the opportunity to speak. And as far as I'm concerned, the child's response to the court without me divulging it, takes a decision to be easier. Decision simply this: the child is remain at cross lines. The reason for it is, again, without divulging what the child may have said, information provided to the court indicates that he has strong relationships with individuals within that school district. And change, though, common sense wise, it makes sense. This child has been through this district for a period of time. This child appears to work very comfortable in this district. And to move a 13-year-old in that situation, that's a child as a result. Motion to move school districts.
If I may, Your Honor, the other two children are not just one-time involved, they are my blood children that I have with my wife.
Oh, no, and I meant that. I just said not, it's not a relationship.
Oh, thank you, Your Honor.
Thank you. This motion to show cause for allegations, violation of personal protection, parties are present. Would you both please raise your hand? Thank you. Court is in receipt of a motion to show cause for violation of valid personal foreign protection order. This motion was filed by the petitioner, Thomas. That petition was filed on June 25, 2024. According to the petition, the motion to show cause, it reads that posting photos of me on the internet, Facebook, multiple instances of coming near me in the Houston area, Walmart, Peril, June 23, 2024. Sugar Festival, Seeking, Michigan, 61484. Still sits at gas station near my house most days in the morning when I leave for work. It's still Ms. Thomas, correct?
It actually was never legally changed on my ID.
Okay, but it may not have been changed on your ID.
But it was elected to be changed on the marriage license. Yeah, so I've asked a bunch of people, it has not really been clear what I should use, so I've been using both.
Well, I know the legal team at this point, so. Ms. Thomas, you are under oath. Tell me why you believe that respondent is violated personal protection.
I got messages from his neighbor last night that he is asking her to pass messages along to me. It's constant. He's posting stuff on his Facebook addressed to me all the time, pictures of my things he's doing that are for me, talking about my wife this, my wife that. I haven't seen him in person nearly as much since we received the paperwork in the mail for this hearing, which again, I know he got them the same day I did because he immediately ran to his neighbor's house. And I don't know why she's doing this. All this. It's all the time.
Can you tell me about your allegation of Walmart and Carol on June 23rd?
So I don't know who was there first. Me and my son were there just to grab a couple of things. I was meeting my son's dad to pick him up. We went inside we had to get like a case of water. As we were walking back to the front, my son mentioned to me that he had seen Brandon. So we went right up to the checkout to start getting ready to leave because again, I know he's not going to leave. So while we're standing there waiting, him and his kids are walking past. They walked past me numerous times, stopped right next to us to say something to his daughter. She's looking at me laughing, like they're clearly doing it on purpose.
Where was father?
My son's father?
No. Mr. Thomas, where was Mr. Thomas?
Right there with his kids. They walked past me twice, I think. The second time they came and stopped maybe 5 feet away from me.
And what is the allegation regarding Sugar Festival?
So that situation, Sugar Festival started on Friday, June 16th, 17th, I think. The Wednesday before that, my old boss's girlfriend called me, who is now his middle daughter's boss. I got her job at the restaurant I used to work at. She had called me and told me, she's like,
Go to what David said. That's your segment. Did you see Mr. Thomas, or was he in your?
Yes, and he was there intentionally because he's telling people at the Sugar Festival.
How far do you think he was away?
I mean, it was numerous times. of various distances. And even after we spoke with the police and he was told that if he sees me and needs to walk the other way immediately, at one point, his youngest daughter was following me and my son from ride to ride. And he's maybe 100 foot away, standing there watching the whole time.
And you said you notified police?
So when I got there, I took photos of him with my dog because she had surgery 2 days prior. And he's dragging her all over town constantly, putting it in my face that he has my dog and won't give her back. He wants to claim, I have the police report. I had to go and ask the officers to write a report because they hadn't written one.
Right, but my question is, you notified police about this, correct?
He did. He brought them to me. I called them Wednesday when I was informed that he intended on sitting up there waiting for me all weekend. And he did.
What about sitting at the gas station?
He was still doing that after we were here on the 7th of June for a while until, like I said, we got the papers for the show cause hearing today. I have not seen him there since we received this paperwork.
Anything else you want to consider?
I don't know. I know for a fact he has a cell phone that is connected to my iPhone through Find My iPhone, and I've asked him numerous times to remove it because it's a child's account that I set up for his daughter. I am unable to remove it unless it is transferred to another parent account. A couple months ago, my brother sent him the instructions on how to do that. He refuses to remove that phone. I don't know why. I don't know what he can or can't see with it. But I have reason to believe he knows where I am all the time.
Thomas, your responsibilities.
Start with the pictures. The pictures that were posted on them were of my family. Father's Day just passed. I haven't been able to have my entire family for the last 65 days. I posted a picture of our wedding picture that was, she still currently has our wedding picture on her Facebook. It's 5 years old. It's been on the internet. It was just brought to the top. I've always had pictures of her and I together. There's my profile picture. It's always been that way. It's nothing new. It's nothing against her. It's not trying to provoke her or anything. She's talking about photos of things at the house. Prior to my wife and I separating, she wanted me to change a lot of things with my life as far as how I did things, what time I went to work.
Well, let's focus on the allegations.
Okay. Okay.
We dealt with that previously. Let's focus on the allegations that you're posting photos on the internet, Walmart allegation, Sugar Festival allegation.
Yes. Okay. The photos of the on Facebook were our wedding pictures and family photos that we had. We just had Father's Day in the past and our 5-year wedding anniversary is next week. And I missed my family. And I posted things about my family and everything. I'm deeply hurt by this. And there was no intentions of trying to hurt anybody with it. Just my family photos there. I mean, my kids are in it. My wife's in that. It's not nothing towards her in that. The Walmart incident. My children and I attended church in Shields that Sunday morning. I had a couple check-in, check-outs at locations in the business. One was in Birch Run, one was in Mill. I then did those. We got coffee, Jim John's, I had receipts for all that being done for Birch Run. We came back through Carroll, which is the closest Walmart between Millington and my home. It was approximately about 3:30 in the afternoon. I pulled in, parked where I normally park, went inside, we parked. We proceeded to get some dog food and paper towel. And when we came back to the end of the aisle, my wife and my stepson were standing looking at Pokemon cards by checkouts. I needed to get some primer spray. I turned and went to the other part of the store. Once I seen her, I was like, oh crap. And I turned and I went all the way to the other side of the store. She was by the checkout. I got what I needed. I got back through the main aisle. My children said, hey, Dad, please, near to the house is going to have me. I was like, yeah, let's go. As we were walking back, my wife, she's 5'4", standing behind a drink cooler in the self-checkout line. I didn't see her as I was walking up. Once I seen her, I was like, Correct. Moved all the way over to the other side of it, away from the registers. And I proceeded to walk. At that time, my cousin's daughter ran up and grabbed my leg. She's 6 years old. She wanted to walk. And I went over, I hugged quick. I was looking towards my wife. I said, I gotta go. I walked around the corner with my back. As we were coming back, I figured my wife, she was already at the checkout. Both times that I seen her, I figured she'd be gone out of school. Came back. I looked ahead so I wouldn't see her. Or try to see if she was there. She was not there. So I proceeded to check out. When we checked out, we went out to our vehicle, got in my truck. At this time, my wife, wherever she was parked, pulled her vehicle at the end of the parking lot. Like she backed in the same row of cars I was in. And when I backed up, there was a vehicle, and I had to go at an angle. And that was the exit out of the Walmart parking lot towards my home. And I was pretty much forced to drive right in front of her on the corner to the light and out of the home. That's what I did. I didn't make eye contact with her or nothing. I just know she was sitting right there. And I had to drive right in front of her. Went home, that was the end of the. Okay, we got what we needed. I didn't approach her, I didn't talk to her, I did nothing. I seen her, and I tried to avoid it. Now, at the Sugar Festival, I'm sure you have a copy of the
If I do.
It clearly states in there that went to the Sugar Festival approximately 2 o'clock Friday afternoon. See a mutual friend. And I asked her if my wife was there because I did not want any problems. She really know I've seen her as long as we do all day with my kids throughout the weekend. And it's not on purpose. I've been going to that Sugar Festival since I was a kid. I've taken my kids. My wife and I have taken all of my kids pretty much every single year as a religious thing that we've always done. Just kind of a tradition. As I was about 2 hours after I got there, I was walking from the back to the front of those concessions. And I seen my wife coming towards me. And I turned and stepped off the grass and I stood one of the point pushing machines. And I put my back to the midway. At that time, I had my daughter, her best friend, and their parents standing. I had our dog with us who had surgery on Wednesday. This was Friday. The dog was fine. I talked to Officer Wilkie, who went over and introduced her to the police dogs and everything. She was fine. She wasn't ready to, there was nothing wrong with her. She was jumping around the house. We had pigs that she chases. She was fine. When I turned and my wife walked past, I was notified that she was taking either video or picture. And I was kind of confused about it. And I turned and I said, what? And she started screaming at me, you got that effing dog here. She just had surgery. And she went out and I'm like, whoa. And then about 5 minutes later, I went and found Officer.
And you didn't walk away.
I was like between a machine and.
He was not, he was standing out in the open. She kind of like had her phone like this and she was walking past me and I just stayed still. Because I seen her coming, I just turned and put my back to her, not to acknowledge. And I was letting her pass. You know, the Sugar Fest grounds are quite small. There's a lot of people. After about 5 minutes, I'm like, she's not allowed to sit here and take pictures of me. This isn't like, I'm trying to avoid her.
There's no court order.
Right, but I was under the impression that both rules apply on both sides.
No, there's no mutual restraining order allowed in the state.
So I'm sorry. Okay,
It's
so
not under mutual restraining. But let me ask you this. I wrote in the original order dated May 13, 2024, to serve on you. Paragraph L, sending to others or posting on the internet photos of the petition.
I didn't post anything new. It was already on the internet. These photos have been on there for 5 years as well.
So how do they pop up on the top?
They're on Facebook, we have photos. Things that you put on it. There's pictures of all anniversaries, there's pictures of kids, there's all kinds of pictures. All you do is you change your profile picture. It's all it was. These pictures have already been on.
Okay, so you changed the profile picture that had your spouse on.
Yes.
Okay.
Which is was pretty much the same picture, just different.
Still a violation.
I understand that. I apologize, I didn't think it was, I thought it was, taking pictures of the public or,
It doesn't say that. It's sending to others or posting on the internet photos of. All right, court's heard enough. All right. Mr. Thomas, I can't make it clear enough for you. But it's all, just a moment. I've heard enough. Sir, just a moment. I've heard enough regarding this personal protection. And what I'm saying is that it's clear to the court that Ms. Thomas does not want to be around you. She's concerned. She's filed a personal protection order for that. Now, when it comes to these chance visits, maybe Carol, Seedling, the gas station, but since then that is stopped. This is my final one. You need to reread the personal protection order that's been granted in this case and follow it to a T. And I'll give you an example. For instance, if you are at Walmart or you're at the Sugar Festival or you are even in a restaurant, it is your responsibility to leave. Not just turn around, leave. Technically speaking, under the personal protection order, and I'm not sure why this has not been followed, but we're going to have a discussion regarding future personal protection order. If the police officer has a reasonable suspicion or probable cause to believe that there's a violation of the PPO, you're supposed to be arrested on the spot.
Right, and it states right here that I was trying to avoid that.
I understand, but you need to hear me out. What I say, the court says it means relative to personal protection. Stop. No more postings, no more chance contacts. If there's a chance contact, the only chance contact should be, I saw her at Walmart, I completely turned around, walked out of the store, dropped what I had and left. That's what you need to do. And you didn't do that. Well, I need contempt for violating the order. I'm not ordering any sanctions. I could order up to 93 days in jail. I'm not fining you or going to send you to jail, but I'm going to do this. I'm going to order 3 days held in abeyance, which means that if you violate this personal protection order again, you come before the court. Not only are you facing 3 days, but an additional 93 on top of it. Stay away from it. Now, finally, relative to this phone, this iPhone. The iPhone, if there is a, you have to have your iPhone, I have an iPhone, the email that corresponds with your iPhone, whatever that is, and you can use that with the Find Me feature, that has to be changed. It has to be changed, so if the child has a phone of one of the parents, that has that phone, it has to be changed to where the child cannot be tracked. Because the child's
That's because I'm a phone. This phone was purchased for my daughter's birthday. I know nothing about iPhones. My wife set it up. Completely, she's underage, she's not. When my wife left, there was a Find My thing that ended up with her brother's phone number on there. I don't know nothing about it. He actually took to try to ask me, said the instructions I was given. I don't know what to do with this one. The other night, I came home after home all day, and my wife posted on Facebook to me. Granted, I will lock the phone every 5 seconds for the rest of my life if I have to remove it from my account. And I did respond to her because when I got that, I seen it. I told my daughter.
You responded to him?
I would love to show you those responses.
You responded to him with a valid personal protection order.
She wrote me first.
I don't care what kind of egg she throws out at you. You are not to respond.
I didn't.
Shame on you for sending the messages to begin with.
I know, I understand that, but at this point, I don't know what to do.
And
I think I've ordered what needs to be done. If you wish to have a personal protection order and you don't wish to have contact with him, don't reach out to him like that. Sir, like I said, I have heard enough. The personal protection order remains in effect, but number one, you understand what you need to do.
Yeah, I just don't understand how,
You're not letting me finish. I didn't order any sanctions other than the time held abeyance. So you get to walk out of the courtroom today. But on the flip side of this, if you wish to keep this personal protection order proceeding, Don't be baiting this job. Don't be sending him messages because you know he's going to respond. And when he responds, that's a violation of the personal protection order.
That is the only time I've done it, and I only did it because he's making it very clear that he is using this phone in some way. And I have it locked out so that it really can't be used, so I'm not even sure what he thinks he's doing.
So if it's locked out, it's not an issue, isn't it?
I don't know, because it's still being used, it's still being charged. I have it shut down on screen time so that it's locked for like 23 hours a day. So why is it still being turned on, used, and charged? All I wanted is removed from my account.
You cannot remove it from the account.
No, because she's 12 years old. Until she turns 13 years old, I cannot remove it from my account unless it is transferred to another parent account. I keep trying to remove it, but it's a 30-day waiting period, and he keeps connecting it to the internet so that it won't remove.
I am going to order as well that the account be transferred within 30 days.
I don't have an iPhone.
Great. That's where you go.
You have to call Apple, and I will unlock the phone entirely so that you have all access to it. I have no problem doing that, but only if it's actually going to be removed.
It's 30 days to remove.
Thank you.
Personal protection order remains in effect. Stay away. Just stay away, sir.
Can I make a final statement
Regarding
all of this? We were talking about this personal protection order, this stuff that's in here, he's over 4 years old.
the motion, this is not a motion to terminate personal protection order.
There was one put in for this also. It was filed on the 19th, and she received it that following Friday. And in retaliation, she came in Monday and put this violation.
It wasn't in retaliation. The incident at Walmart happened between those days, and I brought the police report in. That's why I moved my car at Walmart back by the gas station, because I was on the phone with the police and waiting for them to arrive. And I brought the paperwork in the following Monday, I believe.
Yeah, you have all. She's instructed, and I've heard that she was mad because she got the second appeal. And I wanted to appeal it due to the fact of it not being accurate. It's 4 years old.
It's not inaccurate, Brandon, and when the police chief
Listen,
won't-
I'm not, excuse me, miss, please stop. I'm seeing what the problem is now. I can clearly see what the problem is. The motion to terminate the personal protection order is denied. The motion to continue the personal protection order is continued. The sanctions were already imposed, that is 3 days of jail time held in advance. And if it comes to the court's attention that you are exercising things outside the personal protection order, thank this gentleman. If that, just a moment, sir, I have the last word. If that happens again, and there's a motion to terminate personal protection order, change. So each of you need to lose the numbers. So stop. There's no reason for you to stay to each other. That's my rule. Personal protection order, voting is in custody, school, hearing time, and show cause. Parties are present. Well, we raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right. Ms. Glasgow, you go by. Yes, Ms. Glasgow, you filed a motion regarding custody, is that correct?
Yeah.
And what is the proper cause for change of circumstance you're alleging that the person will get custody back?
I'm no longer.
Anything else? And you just have custody. You also have a motion regarding school.
He
Mr. Alley has a school. What's the status?
right now, he's out.
You have parenting time?
I was supposed to have parenting time, but he's denied.
That's part of the show clause.
Yes.
Mr. Alley, any response to the motion regarding custody?
I don't think she should have supervised visits. She should not have custody. She put her child in bad situations, dangerous situations. Just because she went to rehab doesn't mean she's fixed. I think she needs to show the court she didn't prove her sobriety. She doesn't admit to what happened with our daughter. It's in the newspaper articles. She doesn't prove it. There should be a police report. I'm not sure why CPS is not involved, but I have called them like 2 weeks ago on this issue. She has not been sentenced yet. She still has a criminal case. I've been very cooperative with this family, letting them see her pretty much whenever they ask, until they skipped the last court date and didn't let me know she was going to try to change parenting time before the criminal case itself. Parenting time, I've been very flexible, she was in rehab, well, she was supposed to go with Lori, which is the child's grandmother, and be with Lori and her, but Lori.
Maternal grandmother, I'm assuming.
Correct. Lori would just go drop her off at rehab, and I did not like that. I didn't know where my daughter was going. But I allowed it still. I've been very flexible and
So after you alleged the child went to see mother without grandmother present, were there any issues with the child?
no, but I let that happen for weeks while she was in rehab. You know,
No, I understand that, but my question is simply, after the visit, after you claimed that the child had parenting time with mother without maternal grandmother being there, did the child indicate, and I'm not saying whether the child said it, but were there any physical indications or anything that indicate or
and I don't think she was any stressed out or anything.
what about the motion regarding school?
Well, she's been in bad at school the last 2 years and a half. And somehow, when I did do the sole custody with Officer Mitch, we both, he told me when she do the sole custody, I agreed to the sole custody, that I had to file a motion for her to go to BADX. And I'm like, why should I have to do that? I have custody. And then she's been going to BADX the last 2 years. How is it that she's all of a sudden going to other? He looked right at me. He's like, we don't know how that got into the paperwork. I have all the.
So you're requesting the child go back?
Yes, he said I needed to do this.
So when the child went to, well, let me ask this. You have a joint legal custody?
Yes,
That's why.
I agreed to just, leave. That's, I don't want to take her away from her family. I'm not trying to do that. I just want to have her in a good place. That's all. And I've been trying to be cooperative.
And Ms. Plaza has claimed that you have denied parenting time with her recently. How do you respond to that?
When she had any parenting time with her, she was supposed to establish it after she filed a motion. I said in our contract that she needed to file a motion for parenting time. I was just allowing what agreed with me and Mitch after I got the sole custody.
So doesn't sound like you have a problem with mother having parenting time. Is that correct?
I think it should be supervised.
Okay, well,
I
that
don't
was my
think.
question, but supervised?
And Your Honor, I've offered her I go to work during the day, my sister's at home, and my family has my daughter usually, either my parents have her or my sister. And I told Tiffany she can make time to go and see her. Anytime she wants to, go with my sister, she's supervised.
What's your sister's name?
Amy Slater, she is in court here with us today.
Is it Amy Slater?
Correct. But I'm not sure if my sister will want to do this again, because last time Lori and Tiffany went to my sister's house, Lori did not even get out of the car. Tiffany went in there for half an hour, and it's just bad blood. My sister wants to know what did she do to Lori that she needs to just sit out in the car and not see her granddaughter.
So who do you have as proposed supervisor?
Whoever the state would offer for her to be a professional person from the county or the state.
Just a moment, I want
Parents are not eligible to have supervisors of services or providers. There is no companion file. If they want a private supervisor, we can put them in contact with a couple of options, but they do charge hourly plus private.
My mom is available all the time. And there's no reason why my mom can't.
What's the issue with your mother?
Lori, just with the issue of not coming to court, Tiffany did not want to show up to court. I was working with Lori, and she said she was in rehab, so she couldn't make it to court. But Lori knew I was coming to court. I knew.
But my question is there any harm regarding the child if the maternal grandmother is their supervisor?
She's not around fully.
No, I'm assuming she's around fully. That's my question.
Well, she's not. She works in Bay City and has a job in Bay City. She's not
I
around.
understand that, but court orders supervised parenting time, which would require the supervisor to be there at all times while mother is there. Would you have a problem?
My mom's with her, my dad.
Well, now,
One or the other.
okay, we can't waffle.
I just rather have her with my sister, if anything, that my sister will approve it that way. Cause Lori does not deal with me in the right way, and I can't deal with Lori. But previously, before this case, Lori told me never to call her, it's harassment. And the last 3 years before the case happened.
Is your mother here? Your mother.
My mom's here, yes.
Lori?
Yeah.
What's Lori's last name?
Closet?
Last name, please step up, and you are the mother of Tiffany Clausen.
Yes.
And have you had the opportunity to hear all the testimony this morning regarding this?
Yes.
Now, my question simply is this, and I don't want to mention the child's name, nothing like that. I just want to focus on essentially your role in this case. Would you be willing to serve as a supervisor over your daughter when she has parenting time?
I can on my phone, but as Wilfred said, I do work in Bay City, so when I work in Bay City and I work 12-hour shifts, I usually stay in Bay City for 2 or 3 days I'm working, but my husband is home, he works locally. My husband is home all the time, even when he's working.
Do you have any problems working with this?
And until recently, we were doing just fine. We were communicating. And he had a court hearing. I don't remember what the date is. It was just before Father's Day weekend. He had a court hearing that Friday. And I was supposed to be picking up my granddaughter. And then I got a text message from him, blowing up my phone. He was upset and he couldn't trust me. I don't know why I had to be in court. It had nothing to do with me. And he was apparently angry because I didn't show up in court. I guess, I mean, that's what I'm taking right now, but he blew up with me and said that I couldn't see my granddaughter anymore. And as far as previously, we talked about visitations and me dropping her off at rehab. Very initial visit, I attended with her because the court said supervised visits with me. So, first time that she was allowed to visit at rehab with her daughter, I went. They told me that because that's a rehab policy that like no one else can be there, just like for the kids. So I said, well, I'm not comfortable with that. You know, I don't know anything about the rehab. My first time dropping off my granddaughter, I'm responsible for her. I said, I'm not just driving around. So they changed their policy and allowed me to stay there the first time with my granddaughter. And then as time went on, she was allowed overnight visits. I talked to Rich at Friendly Court, and he said that there wasn't a problem with that as long as it was supervised. So when she was at rehab, there's always somebody with her. That's my granddaughter. So it was supervised. It's just that their policy is, you know, like there's visiting times for the children, and then there's visiting times that they're allowed at in the rehab for the period of time of the abandonment. But the visitation with the children is separate. It's a privacy thing. So she was always supervised with somebody. When it wasn't me, it was somebody from the rehab. And like I talked to Mr. Adley about this. We had this conversation about her spending the night. And in the very first time that she spent the night, I asked the people at rehab to please allow my granddaughter to call. I wanted to talk to her, and I said to her, "Are you okay? You want to stay there with your mom tonight?" And she was okay with it. And I relayed that message to him also. He knew very well that I was in contact with the rehab place the whole time. This is new to me too.
What is your
I'm a nurse. I work from 7 o'clock at night to 7 in the morning, 3 days a week. Every other weekend, every other holiday, my schedule is different all the time.
So you don't have a set schedule.
No.
Describe for me in your own words the relationship between husband and strategy regarding communication.
There's never really been communication much between my husband and him. There was no problems. I mean, there's maybe been once or twice that they've communicated, but it's not been anything regular.
Brad, do you have any questions?
No, Your Honor.
Ms. Healy. Ms. Glossley, there's a motion here for a show cause regarding contempt on father. Are you claiming that there's denied parenting time?
Yeah. When I came home, actually, for 2 weeks before I went over yet, I was supposed to get perk every other Saturday for 2 hours. I was denied 2 of the visits because I didn't show up at work. When he had filed a motion about changing schooling, I missed it because of the fact I really had never told me about it.
But what does the parenting time order have?
April 19th of this year. That order did grant custody, the physical custody to parenting time to Ms. Laza was ordered to supervise alternate Saturday with Lori Laza as the supervisor until such time as Ms. Tiffany Laza. Upon release, she could then file a motion for request of resolution services. That the duration of the supervised parenting time was pursuant to the Lori Plaza as well as treatment facility guidelines. In addition to granted talk time, Mondays, Wednesdays, and Fridays at 7 p.m. And that agreement was entered in lieu of a friendly court.
I was also denied some of the phone calls. I would call you.
What's your position regarding the school district?
I want her to go to school. The only reason she was bad at schools the last 2 years is because they were the only preschool that accepted children that didn't work hard to. That was why I initially had her go to bad at schools, because they were the only preschool around here that accepted kids that didn't work hard to.
Courts heard the testimony of the respective parties regarding these motions. Relative to the motion for custody in this case, the court finds that there is no proper cause or change in circumstance warranting modification or review of the custody factors in this matter. So that motion is respectfully denied. Regarding parenting time under the Shade versus White analysis, the court has heard the testimony again of the parties relative to these proceedings. The court also takes judicial notice of the criminal file involving the class in this case. Based upon that, the court finds that the current parenting time arrangement is in the best interest of the minor child. And so the motion regarding parenting time is respectfully denied in the respect that it is not expanded or diminished in remaining status quo. Now, the reason the court is saying status quo at this point is again, we are pending sentencing in the other file. I'm not sure what's going to happen in the criminal proceedings, but after the pre-sentence report is reviewed, and the courts had the opportunity to hear the testimony or to hear the allocution potentially of the defendant and hear from defense counsel and prosecuting attorney, then we'll determine what the sentence will be at that point. So I have no idea what that is. However, parenting time is to continue every Saturday pursuant to the previous order. The court heard the testimony of Ms. Lori Plaza relative to her involvement in this matter. Father is requesting that his sister be the supervisor. But under the circumstances here, the court is going to order supervised parenting time pursuant to the previous order. The court will modify the previous order, including Mr. Glaza as an alternate. What is your father's first name? Kenneth. So Kenneth or Laura Glaza will be supervisors while this matter is pending. And if mother wishes to address it after sentencing, certainly can as a third final motion. Relative to contempt in this matter, court finds that there is denied parenting time in this matter. Find father in contempt. I'm not ordering a sanction in this case because again, this is a fluid case. However, Mr. Abley, absent some compelling reason, the parenting time is to continue. Saturdays for the 2 hours supervised by either maternal mother or maternal grandmother or maternal grandfather. Finally, relative to the issue of, and she's entitled to makeup time relative to that. The court will order makeup time for 4 hours. Mother to be scheduled between the parties here as quickly as possible, but it has to be done within 6 months. Finally, regarding the motion to change schools in this matter, parties have joint legal custody in this matter. The child has been, strike that. The court heard the testimony of why the school had been changed. However, based upon the current situation in this case, Bad Axe is the appropriate school. Or the order of Bad Axe Public Schools being the school district which child attends. Schultz, is there anything I'm missing?
We're relationships specify the Saturday and weekend present.
Was it 12 to 2? 1 to 3. Is that what you understand it to be, too, sir?
I can do whatever they, whatever they need.
What works, while we have it both here, what works for both?
Either time works for me, so just tell me.
Whatever.
12 to 2? Is that okay with you, sir?
Yes.
12 to 2. Those parties agree. Anything else, Michelle?
We're also continuing the provision.
Oh, yes, priorities remain in effect.
Your Honor, can I say something?
No, but can I have your name, please?
I'm Linda Glaza. I'm Tiffany's aunt.
No, unless you're a party to the action, your call is witness. I mean, no disrespect, but
Because I could be,
I have to follow court reform. I have to follow the rules. That's my ruling in this matter. Let's see how things go. This lots of continued success in your recovery. And bottom line is, both we need to work the best interest of this child, because this child is going to sponge up everything. They follow you, they follow you. And I want this child to be successful. Good luck. Offer. 7:75 p.m. This will be a motion for custody, legal custody in this matter. Parties are present. Would you both please raise your right hand?
do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
We are, again, not using the children's names, but Mom, we're requesting full, well, actually, let me ask Ms. Schultz. What's the status of the custody order?
On February 6th of 2024, the court issued a written opinion regarding custody of the lead. That order continued the finding for joint legal custody, granted Ms. Barnes sole physical custody, and continued Mr. Rush's parenting time at a duration and frequency as determined by the Department of Health Services. So
As far as why you're requesting a legal custody?
Just so that way, when it comes to major making decisions for the children, I'm allowed to without trying to get permission from father, considering he hasn't responded to me in over a year. He hasn't spoke to the children in well over a year. He hasn't seen the children well over a year. At this point, it's pretty much abandonment, really. But
Have there been issues over the last, well, since February 6th, that you had to reach out to father regarding medical?
well, the children's medication, the children were making sports, that I spoke with Ms. Schultz, and she said, you know, I can just message father and app close just to let him know what's going on, but I mean, he hasn't even been on app close since July 1st of last year. I mean, how can I do anything if he's not cooperating?
Anything else?
Actually, so my phone did an update. I have an iPhone, and when it updated, it logged me out of AppClose, and there's no way to log back in. It wants me to recreate AppClose, and I have my phone to prove that if you need to see it. It's been like that the entire time. I've had no way to contact. She's had other sources to contact me. She could have got a hold of Carrie Kindness to contact me. She has my phone.
Is there an order exclusively? Yeah.
Yeah.
parties are required to use app flows, and I will note that app flows has a tech support in it.
Have you reached out to them to get that back up?
Tech support, no, but I can do that as soon as I meet her.
Yeah, and may I say one more thing? And furthermore, I shouldn't have to go through other people to try to speak with the father and children. Harry Kindness is not their parent. All she is a foster care worker. It's time to be an adult and grow up now. It's been well over 3 years that this has been going on.
This is a motion for legal custody filed by Ms. Barnes. The parties have joint physical custody. I'm sorry, they joint legal custody, sole physical mother. The request is for sole legal custody based upon allegations by mother, by patient, as well as allegedly not being contacted. Father has stated that when it comes to his app close program, either purchased a new phone or something happened with the phone where he did not log back in. Or Ms. Schultz regarding that, she stated that tech support can be contacted to reset that. That would be a wise idea. I don't find any change in circumstance or proper cause to warrant a modification of custody in this fact. However, what I'm going to order though is that father must contact tech support and reset his app close program within 7 days. If it is not done within 7 days, and there's a continued lack of communication, whether you can bring a motion to address that, we can address it at that time, whatever may happen. However, the parties need to be able to communicate because these girls are getting older. There may be a circumstance where one of the children falls off the bicycle as he gets hit. And when legal custody, mom's sitting there trying to reach dad and dad's not responding, something has to be done. And I wish I could order, and I don't think I can, but maybe I can be corrected on this, but if I don't get, I would like possibly that if father doesn't respond within a certain amount of time, the mother can do that. I don't think I can do that at this point. But father, you need to be enrolled in app close as quickly as possible. If it is not done, and something has to be done regarding the children, and Ms. Barnes comes in and says, look, I tried to contact you. You're trying to show cause her. There'll be no show cause because you were well warned to make sure you have your app close program on. So again, motion for custody respectfully denied. Based on lack of proper cause or change in circumstance. But father is required within 7 days to get app close up and running. Or will also require that as soon as it is up and running or you're unsuccessful, you must report that to the front of the court so they can help you as well.
As a side note, Your Honor, this matter is not noticed for today's hearing. But we did receive a complaint from Mr. Rush on Monday with regard to a Facebook Messenger post that was allegedly sent by Ms. Barnes. I can't tell who that message was sent to, but it does address various circumstances related to the companion file. And I would have the court to strongly remind parties that there are standard communication provisions within the order and that.
I don't know anything about this. This is just the person's come to me. I don't want to hear any explanation. But there are specific provisions that must be followed regarding if party is in violation of one of those conditions and it's brought to the attention of the court. Someone can be held in contempt. And contempt can include anything defined as no, set it up. My rule.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Ms. Schultz, do you have anything?
Governor, I will note that there is a pending custody and parent investigation regarding the family. That matter does remain pending. I believe this point I had an opportunity to interview both parties for the issues of the recommendation. However, in the interim, we have received complaints from Mr. Plant alleging that the court's no contact provision regarding Mr. Russell has been violated. It was my understanding that I advise that she does plan to continue her romantic relationship with Mr. Russell, and the children are not with her, that he is still residing in her home. Mr. Plant has provided video documentation showing Mr. Russell had contact with children. He contacted our office this week. I obtained a police report from our Police Department that as of July 8th, the children were present during another dispute between Ms. Plant and Mr. Russell in the parking lot of their apartment complex, that the children observed those interactions. My understanding is there has been additional police contact yesterday.
Is it plants or plants, sir?
It's plants.
Plants, Mr. Plants?
Yeah.
What's going on here?
The situation is that Brandon is basically living in the parking lot right in front of the apartment complex. And my children, they go outside and play, and they're constantly around him, like not like around him, but he's around, like in front of the apartment complex.
The court has attached to the motion, looks like a video snapshot of at least 3 vehicles. Ford and a Chrysler minivan. There's an individual with a hat on and someone in the back seat of the car. Does that sound familiar to you, Mr. Klein?
Yes.
What is that depicting?
That Brandon was around. My daughter was in the back seat while Brandon was talking to Ashley's mother.
And who took this photograph?
I did.
You live right near each other, right?
Yes, we live right next to each other.
What's your response?
I have a couple, but one of them I would not like to bring up because it just happened yesterday and I need to get a police report printed off. That is another issue we had yesterday.
Who's we?
Me, Brandon, and Justin.
And Brandon is who?
Brandon's my boyfriend.
Okay, impressive. So.
But the date that he took that picture, my mom was there and she just asked him, because he was on the other side of the car, she just asked him if she could put, or if he could put her walker in.
So why?
My mother was picking the children up that day.
Why is Mr. Kressel even around?
What do you mean? Why is he not around? Other than he has nowhere to go, he's letting me use his vehicle. He didn't have enough time to seek housing because he's not from this area. And not only that, Justin and Nicole have been stalking me and causing several issues. I know that does not have anything to do with today's order, but I'm just letting you know what to be aware of what's going on a little bit. I know it's really not my place to really say what this, because it has nothing to do with this motion, but I needed you to be aware of some of the issues that's been going on. I do not feel safe for Justin to be in the area because I have nowhere else to go as well.
Both
So-
of your own residents.
Exactly, and I can't even go outside, Your Honor, without him and his wife and the neighbors stalking me.
Okay, well, you're going to another issue. Let's focus on what's here before the court.
And that is part of another reason why Brandon's in the parking lot, because I do not feel safe without Brandon in the parking lot. Especially after what happened yesterday from Justin.
Despite a court order.
Huh?
Despite a court order saying he's not. Right?
Can you rephrase that?
Sure. Mr. Kressel's not to be around, direct, indirect contact.
He wasn't, Your Honor.
Photograph doesn't show indirect contact.
My mother asked me, I was in the house at that moment. My mother asked Brandon to put her walker in a chair. There was no contact whatsoever. I understand that there was a distance there. I understand that. I was not really aware of it.
Who was the lease to your residence?
I do.
Okay. Is Mr. Kressel on the lease?
No, sir.
So
And he is not living with me.
Is he living in the car?
Yes, sir.
Where does he go to the rest?
I'm not really sure. That's not, I don't know. I assume the porta potty or Brown's. I don't ask him. It's not my business.
So are you saying that he never goes in the house?
Only when the children are gone, he comes to the house.
And how often are they gone?
It depends. When Justin's been wanting this 2 weeks, 2 weeks off, 2 weeks on for the summer after, I forget his name, Holdwig, I think.
Mr. Holdwig.
Yes, Mr. Holdwig suggested that. But we've also been having issues with Nicole as well. But I just got out of hospital yesterday, so my mind is a little all over the place.
Was your significant other, Mr. Kressel, convicted of domestic violence second offense on April 4th this year?
April 4th?
Yes.
Can you rephrase? I'm sorry, I'm not.
There's a judgment of sentence in the file indicating that Brandon Keith Pressel was found guilty on April 4th of domestic violence second offense. And
because we didn't have proof against Justin, we couldn't take care of that issue.
who was the alleged victim?
Supposedly me, but I was in the car. Justin attacked Brandon's door
The jury.
on the passenger side.
Ms. Schultz, have we had this issue brought before regarding?
The referral order, based on the allegations of violence, the referral order that entered on April 30th of this year, it is specifically addressed that Mr. Pressel shall have no direct or indirect contact with the minor children until further order.
But that's what I'm trying to say. There was no contact. He just went to put the car or the walker inside my mother's car.
But has she been, so we've had no prior violations?
We filed this one, however, since the show cause was filed by the friend of the court office, based on the police report I received from Harbor Beach dated July 8th indicates that while Officer Wilson was on duty, that there was an argument within the apartment complex. This Lance was on the driver's side of the silver vehicle, to belong.
July 8th?
Excuse me.
I'm just trying to figure out the day, Your Honor, that's all.
That Mr. Pressel was inside of that vehicle. Officer Wilson stopped, activated his body cam, made contact with Ashley. She advised she needed to get to work. Brandon would not get out of the car. Ashley's two children were standing outside of the apartment. Well, Brandon then got out of the car. The two engaged in a verbal argument. Ashley put a car seat into the vehicle and then had her children get in. I stood by while this happened, and then Brandon went to the apartment and then couldn't see.
Like. I heard nothing. Ms. Lance, I find you in contempt of court, violating the court order relative to indirect or direct contact of Brandon Pressel with the minor children.
So how is it a violation when he was just putting a car or a walker in my mom's car?
No direct or indirect contact with children.
So I have to tell my kids to get out and leave the area for him to help my
This
mother?
is what you need to do. Brandon Pressel is off limits, period. If you choose to have a relationship with Mr. Pressel, and that's up to you. If you choose to have a relationship with him, I'm not stopping you from that. But the children are not to be around. I'm going to order that Mr. Pressel shall, prior orders will remain in effect. The court is also going to order that Mr. Pressel not be within 500 feet of the residence of Ashley Plants. So
what do we do? Take a measuring and document everything?
that's what needs to be done. That's what needs to be done.
Okay, well, I already had to put 2 security cameras out in front of my car or in front of my apartment due to Justin, especially attacking me yesterday.
Well,
I do have police reports for that as well, but I will put in a motion for that.
You sure can. The court is also going to order you serve 3 days in the county jail.
Is there any way around that? Because I don't have money to be going against for an attorney. Justin's been causing me so many problems. Him and his wife's been stalking me.
Ms. Lance, you've not filed a motion to that effect. You violated the court order. And when I say a person is off limits regarding the children, it's not me trying to be mean. It's the best interest.
I'm not safe there if he's not there though. And neither are my children. He hit me with a car yesterday.
I don't have that information.
I would ask the police to
Excuse me,
get.
Ms. Lance, I'm going to tell you to stop because when I made mention, your significant other was convicted of domestic violence second offense against you. And the children should not be.
We were set up that day. It was not a domestic violence.
That's not
We
what
were
the jury
set
said.
up.
Regarding the 3 days in jail, if the court will do this, the court will hold that in advance, which means you don't have to serve the jail time. If you come back before the court and it's proven that this provision has been violated again, don't worry about 3 days. Worry about 93 days. There's no work. I mean business. Mr. Pressel is off limits.
That's not the problem though, Your Honor. It's Justin and Nicole.
Again, we did not file a motion to address that. This is what's been brought before the board. I mean business. Mr. Pressel is off limits, period. If he has any personal property in your apartment, it is to be removed.
So
Anything within the home, he is not to be there. I'm ordering him away from your residence, regardless of whether the children are there or not.
what would make you see that he's not violent then?
File a motion. File a motion.
So how am I gonna be safe when he's gone then?
You have law enforcement, there are other means of.
Don't listen to me.
This plans, I'm not going to argue with you any further. You're done with this. He's off limits.
So he's gonna get away with this?
Who's getting away with?
Justin and Nicole are gonna get away with sabotaging us.
You didn't bring a motion to address it. This is contempt regarding you. You know what you need to do.
I don't have money for a lawyer. I can't afford him anymore.
That'll be all. Objection in front of the court recommendation. Will both parties please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Thank you. Ms. Schultz.
The court had ordered the friend of the court to conduct a child support review. That review was completed and the recommendation was issued that Mr. Crash pay child support in the amount of $599 per month, including $25 ordinary medical for one child, effective January 31st, 2024. Is this his objection?
Thank you. Is it Karish? I want to make sure I'm pronouncing it correctly.
Karish, yes, sir.
Mr. Karish, what is your objection?
My objection is just, I have a lot of bills and I'm the sole provider in my household. My wife is not working as of right now due to health issues.
Objection.
Oh, excuse me. What's the objection?
She can work, so the whole motion that he is the only provider is no longer true.
Go ahead, sir.
She had stroke symptoms because she had a gallbladder removed and everything reverted back to her stroke when she had one 10 years ago. And like, it's me being the sole provider in my household, it's hard to pay up to $600 a month because of all my other bills and rent and so forth and so on. And I'm not working as many hours.
Your other bills? Well, what are your other bills, sir? Because bills are not relevant for the court to consider.
I'm just saying with all my, like my household bills, my car payment, my rent, so forth, stuff like that.
But do you admit though that the income information that the friend of the court utilized was correct?
That might have been from last year. It's not my income this year, sir.
Did your income change?
Well, I'm not getting as many hours.
But you're at least getting 40 hours, correct?
Close to, yes.
Okay. Anything else?
I'm trying to be fair, and I would like to ask the court if it's possible to drop that down. I can afford an extra, or I can afford $400 a month for child support.
What is the current obligation?
Excuse me?
What is the current obligation that you have to pay?
According to what they said with my review was $590 something.
Oh, no, that's just what was calculated recently.
There is no child support in place at this time. The child was previously with the defendant, now back. There's not.
Oh, okay. Well, if there is no public assistance involved, the court can allow the parties, if they wish to agree to a lesser amount or a higher amount, whatever they wish, as long as it takes care of the child. You're requesting $400?
Yes, sir.
How much your position?
I request 800, so I think we should go with what FOC says.
Why are you requesting 800?
Because in 2019, when we had started, going to court for child custody, it was for $400. He didn't pay it then. Inflation was 1.9 then, now it's 3.8. It has doubled since he had to pay $400 years ago. And he's still trying to do that, which he never did. And I waived $7,000 of that away. So he still clearly has never took responsibility for being a father, not from the time she was born, not when she was 5, when FOC got him for $400, or not now when he kicked her out 2 weeks before Christmas, took a family vacation without her, and still to this day hasn't gave a dime to help his daughter out. And now he still doesn't want to pay.
Officials, can you explain to the parties when it comes to what support is calculated, what the front of the court looks at regarding the recommendation, what the court not looking?
The friend of the court will consider the overnight schedule that exists or the actual size of appropriate will be generally the order in regards to the court's the incomes of each parent, not the household income of the parents. The cost for any healthcare coverage, any daycare expenses if the child is under the age of 12, and
And then we also look at allowable deductions such as types of things, retention. But we do the information outline for formula. We do not consider personal expenses, our payments, mortgage, rent, so it's not relevant.
And that's where the court's coming from, Mr. Parrish, as well.
Yes, sir.
I have to follow these rules. That's what the court has to follow. And in this case, what you are alleging is, well, first, regarding your spouse, that's not even for the court to consider. That's mom and dad. Number two, if we look at the income, we do not look at the expenses, whether it be mortgage, car payment, Netflix bills, whatever it might be. I asked whether or not the parties would agree to a lesser amount. That has been requested by the plaintiff, by Mr. Parrish, denied by mother in this case. And as a result, the court has to follow the law and the court order that's the court made based on the recommendation of 599 to 599, of which $25 is ordinary medical, effective January 31, 2024. I can't recreate the law. I have to follow the law. That includes. Thank you.
It would have been on the 5th.
You still living in the county?
I am living in Pigeon now, but I did still pay our mortgage on Friday for the Ondale address.
So you're proposing alternate weekends and one day during the week?
Correct. I would like to do Wednesdays if possible.
So what do you request?
I wanted to at least have them, like I said, 1 week on, 1 week off.
The oldest is 9, right?
Yes.
Where do they attend school?
Lakers.
Okay, so you're right in some school district.
Yeah, we're like right in between it, the both of us.
Three of the children will be attending schools.
Yes.
And you're in the family home?
Yes.
So adequate beds, all that?
Oh, yes.
Can I speak on that? He's living in the home that we both of our names are on it. We have to get that figured out. I just paid the mortgage on the 5th along with paying my rent for the new house as well. Because I chose to leave. The house that I'm living in also has adequate beds. It has everything that is needed. Everything essentially that is at that house are things that I have bought and I left there. So that way he had the means to have the kids when it was his time.
You're not alleging he's a bad father, are you?
I am not alleging that he's a bad father, but I would say that he is struggling with some things that he needs to get taken care of in order to be able to work towards having them for more time. There has been issues with alcohol in the past, and I don't think that is something that the children should be around. I also know that he has a recent medical marijuana card, so there is issues of that, and he's going to be at work during the day. His mother is currently staying there and she would have them. And yesterday alone, when I went to grab the kids, she had called the police on me for grabbing the kids because she could not keep her cool.
She got in a fight with my 8-year-old mother.
Well, you're working, sir?
Yes.
What is your work schedule?
It's from 5 in the morning to 3 o'clock.
And do you have any issues taking care of the children?
No.
How do you take care of the youngest based upon that child's feeding?
I have formula and plus she has frozen.
Okay.
Present.
All of my frozen breast milk that I have is in my possession as well. Sorry, if that makes a difference. And my only thing is just he's going to be at work for a big chunk of the day. My job allows me the flexibility to work from home 3 days a week. So I'm going to be there with them for those days. And the 2 days, it would be Tuesdays and Thursdays, would be the only days that I would need somebody to care for them.
Any party convicted of domestic violence or assault?
Not yet.
Yeah,
Not yet.
I'm going through that case right now. Domestic violence.
Was he alleged? That matter's pending?
Yes, I have court on the 27th, I believe.
27th.
Is it arraignment, pre-trial, trial? Have you had hearings already?
Yes.
You have an attorney representative?
Yes.
Is it alleged that the children were present?
No.
No, they were not present.
All right, this is what the court is going to do on an interim basis. This will not create a custodial minor. Or will order at this point. Father shall have. Do you work weekends?
Sometimes, if they ask me to.
You have the right to decline them.
Yes, I do.
Fathers awarded weekends 1, 3, 4. Friday after work to. What time do you start working with that?
5 a.m.
5 a.m. Sunday. You go Friday at 6, Sunday at 6. 3 weekends a month. This day. That's it. 4. Okay, 3, 4. On the issue of, and that's going to pertain to, actually, if there's milk available that's frozen, that'll have to be delivered. Now, there's probably a no contact provision between the children.
She lived it.
The no contact order was
It was
lifted so
lifted.
that way we could discuss the children.
Okay. Okay. So mom, you're to provide the frozen breast milk, dad, on these weekends.
I will with what I can. I'm not responding to a pump as well.
I understand. And I've lived it too, so I get it. I know how it works. But to the extent that you can, give that to father. You can speak with each other. Can you meet with each other?
We can. I would prefer to meet with him than to meet with his mother, because like I said yesterday, I was just going to pick them up and to take a couple of the baby's items that him and I had agreed upon. And that's when it had become an argument with her.
What time do you get off on Friday?
3 o'clock.
3 o'clock. And do you work from home on Friday?
Yes, I do actually.
Okay. How far is your work to?
I live in Oakton, or work in Oakton, I'm sorry.
So can you be, I said Friday at 6.
We could do right after he gets out of work.
Friday.
I'm okay with that. Yes.
Oh yeah, I could be there like in 15 minutes at her house.
Wait, 3:30.
Okay.
3:30. I don't jump the rules. Friday at 3:30. Return the children Sunday. I'm gonna make it 6 o'clock on Sunday.
Yeah.
Yeah. Okay. This is an interim order. No established custodial requirement will be set. That's 1, 3, and 4. We'll further order the court regarding the home and all that. And I will be in another motion to file.
I'm sorry. Another motion will have to be filed to,
You mentioned something about the home.
right, to determine what
That's not
happens.
before the court today.
Okay.
I will just note this is a custody action that you see.
Oh, that is true. Yeah. We're not dealing with that. We're just dealing with custody parenting. In the interim, the court ordered that the parties have joint legal and joint physical custody, which means that you have equal decision-making power regarding children's medical, education, religion. And I'm saying on the interim joint physical custody, that presumes that the parties have at least close to equal parenting time, but this is only an interim determination. This is not a final decision. So I'm just going to place that there now. Or be referred to the front of the court. And another recommendation from the front of the court.
The alternative is a resolution to freeze.
Correct. That means if you're able to work around the court on your own rather than having me here. Believe me, sometimes it's a lot better that way because the rules of evidence apply here in the courtroom. They don't apply in the court office. So to the extent that parties can speak and communicate with each other, that's going to go along. Right? Court will also order that the parties communicate by half-closed primarily, no derogatory comments regarding the parent. Because we have 4 what I call valuable, maybe be him and she's young children. And they're going to sponge up everything that both of you are doing. So you have to be able to work together. 1, 2, if you act outside of those lines, they pick up on that and they can act out. And you don't want a 9-year-old, much less a 4-month-old. What am I missing?
I am satisfied with the court's order other than the effective date for the child support recommendation. And the
years.
Okay, fine.
That the complaint filed on June 13th.
June 13th it is. Any questions, Mike?
So this is just temporary until another motion is,
No,
Sorry.
No, until there's a front of the court recommendation. They're
Okay.
going to review and interview both of you, get information. There'll be packets that both of you should be receiving. I would go to the front of the court's office right after this hearing today and get those packets filled out. If there's support letters you want to add, anything.
We
We want to hear.
we will send you additional functions and forms, but the packet is very lengthy, so I suggest we clean it up today. We'll then contact you to schedule the meeting, and if you don't have a agreement, we will.
okay, thank you.
She both best.
Thank
Yes. Thank you. Ms. Schultz.
Your Honor, the parties have 2 children in common. However, there was a prior order that was issued out of Oakland County with regard to their oldest child. And with regard to the Oakland County order addressed custody and parenting time, a subsequent action was brought through a family support action with regard to the minor child R. R was referred to the friend of the court for an investigation regarding issues of custody, parenting, and child support. Here.
Yeah.
And after we received the referral, we did coordinate with the Oakland County friend of the court to have that file sent here so that everything could be consolidated. But for background, the referral order only addressed R. So our investigation only focused on R because there is a court. And so we did complete that process. A recommendation was issued. Mr. Wu did timely object to that recommendation. It is a full custody parent recommendation, so I don't know if the court would like for me to start with what the recommendation is. And we can go forward from there.
Let's do that. I don't know. While you're looking at that, what is the order relative
He, his captaincy is granted solely for custody, and parenting time is ordered as reasonable. It does not have a specific extent. And as it relates to our friend of the court had recommended that Ms. Captaincy be granted full legal and sole physical custody. We did specify that we were not making a recommendation for custody as to E, as we already said. That Mr. Blue, we granted supervised parenting, which would include 1 weekend per month, year round. The parties were unable to agree that the weekend parenting time would be exercised on the second weekend of each month, from Friday at 6 p.m. until Sunday at 6 p.m. 1 week per month during the summer break school in each month, June, July, and August, with Mr. Blue to select the dates by May 1st of each year. If he did not select his, if the date selected by May 1st was provided to if dates were not selected, then it was recommended. Period, from Sunday at 6 and Sunday at 6. Alternate holidays for the 2022 holiday addendum, with his being granted those holidays in the entire Mr. Blue granted those holidays, as well as any other times that the parties may be. That the children remain together for purposes of the parenting time outline. That Leanna Blue, the paternal step-grandmother, supervised the parenting plan at her residence for a period of 1 year, or until Mr. Blue petitioned for a redetermination of that issue. That Mr. Blue completed the anger management course as well as a parent education course prior to the transition to unsupervised parenting time. With completion being provided to the parental court office. That reasonable rights of comp time be granted if the parties cannot agree that comp can be exercised on Tuesdays and Thursdays at 7 p.m. And that may include the use of video conference such as Skype, FaceTime. That transportation may equal shared between parties. If they cannot agree, then the non-custodial parent will be responsible for transportation. The custodial parent. That the parties would allow to have a responsible adult transport the children for parenting time, with the definition according to the parental court policy, licensed individual over the age of 18. parties utilize outflows for purposes of non-emergency communication regarding the minor child. That communication will be limited to issues regarding the children. That neither party will speak in a negative or critical manner about the parent, is or her household members. And that provision applies to verbal comments, text messaging, and social media posts. That neither party discuss the topics with or in the presence of children. That the parties complete the SMILE program as previously ordered, and that we completed within 30 days. And that child support cable lines are be ordered. For 2 children effective July 1st. However, since that recommendation was issued and the objection was filed, the friend of the court office was contacted by Anna Blue, who is the supervisor. Blue indicated that she is no longer willing or able to provide supervision. In addition, the friend of the court office did receive a couple of reference letters, one from Mr. Blue's mother, Christine, as well as a receipt
Kukowski, sorry.
Thank you. And Mr. Blue also had sent to the court office a video, audio recording, that was interactions between his mother and stepmother. Case.
Sworn. Mr. Blue, what is your objection, sir?
Pretty much this is kind of one-sided. Everything that's in this recommendation, she's been saying for the last couple of months, since before the recommendation was even ordered. This is ordered June 24th, 2024. She's been saying this stuff for months now. So like, I feel like this is just hogwash, half it's BS. I've been in my kids' lives for, I don't know, their entire lives at this point, up until the point where me and her had a domestic violence incident. And I will say this at this point, if half the stuff that she's saying about being here, if this is how you felt, you should have let me go to jail way back when, but you didn't. Now we're here. When the kids were living with me, you moved up here.
Focus on me.
Sorry. She moved up here. I allowed them to come up here because I asked them. I'm not putting my own feelings in front of my kids and say, what do you want to do? You want to go back and forth? They said yes. I let them go up there. Everything was that. Me and my mother had an incident where she didn't like what I was doing. She kicked me out. That's hearsay, but this one afterwards took full advantage of that. And because I didn't have a place at the time to take my kids, they were stuck up here, you know, and now that we're down the line some, I was helping her. I was giving her money every month. It wasn't consistently every month. It was when she asked me for it because, you know, I was working my job. I had to pay my own bills outside of that. And when I stopped paying, like when I stopped giving her money, it's because I purchased a car. It cost me a little bit more than I thought it was going to. She started coming at me crazy, talking about me doing a bunch of other stuff. I was like, okay, at this point, I'm done helping. So she got the courts involved and she's telling me now I have to pay money or I can't see my kids. And mind you, this entire investigation, it's been recommended that I have like time with my kids. It's been a struggle to see my kids. It's always been about money. And if I don't have money, I can't have my kids.
And the Oakland County order just gave reasonable parenting time. So there's never really anything spelled out by that court, correct?
I was 16 at the time. I didn't know any better. And me and her were kind of living together.
Okay, how old are you now, sir?
28.
Okay, but even from 16 moving forward, when was that order entered? That order?
Yeah.
I'm gonna ask you shit. We're talking 11 years. What's the status of your relationship?
Currently none. After I caught her in multiple lies, I kind of just cut them off. I don't want to deal with them. I don't want them around. She was looking at me and pointing at me and smiling. And I'm just kind of like, stop. Like she touched me on the way out. I'm just like, can you please just leave me alone? I don't want anything to deal with it.
So based upon this recommendation from the President's Court's office, obviously she could not be a supervisor. Right?
Correct.
If the court went that way, who would be a supervisor?
I would ask for my mother, my sisters, somebody different.
What's your mother's name?
Christine Blue.
Sisters?
Jessica Bradley and Sierra Blue.
Anything else before I go to the other part?
Nothing I can think of right now.
Thank you. This is your response.
So he had no issue with his father or his stepmother, no real issues anyways, up until about around March, the beginning of March, when we started doing the visitations over there. Then he claimed that they were disloyal to him for working with me. On top of that, I continued the visitations, like I had everything written down, you knew about it. It's not about the money, I've been told, and I don't care about the money. He's not gonna pay anything, he's been very clear on that. And regarding to him helping me before, he was not.
So
It's not
you
about.
agree with this recommendation, right?
I do, except for after his last visitation with Leanne at his school.
Well, but you didn't object, to it, right? You didn't object to the
No.
recommendation.
No, I didn't, but Leanne requested to be taken off after the last visitation where it was June 7th, I dropped off the kids. Anthony showed up on.
We don't need to go into details,
Yeah.
but stepmom doesn't want to do it.
Stepmom or his father because of his behavior towards the children.
What about Christine, Jessica, or Sierra?
Jessica already stated in previous messages, which I have in my phone somewhere, where she will not supervise her brother with the children. This was while.
Not here.
What
about Steve?
I have a lot of concerns regarding that.
What are your concerns?
Well, she is verbally abusive towards me and the children. She belittles me in front of my children. But she also does it to the children. She explains things to the children that they do not need to know. They don't need to know my history. Yes.
What about Sierra?
Sierra is very young and.
How old is Sierra?
I think she just turned 20. I don't really have an issue with Sierra, but I know that she is not going to stand up for her brother if he's doing something wrong with his children. I have big concerns regarding Christine being supervised visitation, not only because of things that she has done, she has also left my children in our car in the city for over an hour with no adult. I was on the phone with them the whole time, but there was nothing I could do. I was 2 hours away. The last time
How
I
did you know
left,
that?
I was on the phone with my children. My son has a phone, and I was on the phone with them.
How old is he?
Ethan is.
I want to know the first name.
He is 11.
Is that the person called?
Yeah, I called him to check on him, see how he was doing, and they said they were sitting in a parking lot. Granny was in physical therapy for over an hour. My daughter was crying about how she had to use the bathroom and she couldn't find grandma. So there was that situation which she justified as that little thing. There was also the time that, she was there with Anthony. They made me leave the house. And when my daughter was dropped off at the grandmother's the next day, she had bruises all over her backside from Anthony. He admitted to doing it. She was 3 at that time. And I provided proof of that as well. Along with proof
Was that
that
provided to the front of the court as well?
Um,
Was that information you just testified to provide?
Yes, yes, it was. Along with pictures as well. I have included multiple, screenshots of the family saying basically that they can take the kids no matter what I say. It doesn't matter. They can take my kids, which is why I started hearing that they were going to take my children from me. But the last time that Christine flew, I had emergency surgery and all that. Christine was transporting my son back up here for a basketball game. He was over an hour and a half late for that game. They did not allow him to play, and he broke in the back of the uniform from Detroit up here in the back of the U-Haul. My daughter was also not in the seat. She was sitting between the 2 front seats of the U-Haul. And that is when I had enough of trying to work with them, and I went to working with his father and Larry, because I've never had any issues with them. They have a very good family bond with their 2 kids, and family things are easy to plan with them, birthday parties, stuff like that. Communication is very clear, cut and dry. There's no fighting, no anything like that.
I think I understand. Mr. Blue, what is your thought about your father being a supervisor?
He's not my biological father, and he has missed the lies and the crap that's been going on with her because he doesn't tell me.
What?
He's not my biological father.
No, I understand that.
He's missed the lies and all the BS that goes along with her. He hasn't been telling me anything. It's all been just her and Leanne. My dad just takes everything idly and just lets it be.
Well, all they're looking for is someone to supervise.
I don't need a supervisor. The only reason why I need a supervisor is because she's saying this. And I want to go back to what she said a minute ago. The reason why we drove Ethan back up here at that time when mom's car caught on fire and it broke. The only way we could get back up here was with the U-Haul. Wasn't the best idea, but it happened. And once again, she is no more perfect than anybody else in this room.
Did you mention though that you were at least allegedly involved in domestic violence?
Who?
Yes,
Yes,
and I have
years ago.
What year was that?
2015, 16. Sorry, 2019. My bad.
Ms. Schultz, are you familiar with the other proposed supervisor?
Only to the extent that each of them family members, just the reason.
Sure, no, I would expect.
I think I have so much information.
A lot.
I recognize, part of what I had received from Mr. Blue's mother, did indicate that he may have already. And part of my concern was both the history of domestic violence as well as the pictures that were referenced. And so if it was alleged that the marks that were left that corresponded to screenshots of text messages. And that's where my recommendation came from. According to what his mother had stated, he did have a referral related to a criminal proceeding.
Yes, sir. I did counseling upon that too. And to note on the picture, I do understand there's a difference between discipline and abuse. Yes, I may have smacked my daughters behind on a little too hard, but at the end of the day, it was where it was supposed to be on her ground.
Sorry, so discipline and abuse, there is one. And when you're leaving with your handprints and bruises on a 2-year-old girl because she won't go to bed for you, that is a very big problem to me. He did complete his anger management after the domestic violence situation. And it was 2018. After that, we have had several issues, but there was, I called the cops made him go home, stuff like that. But I don't, his anger that he still holds for me, it likes to do any of the text exchange between us. It is affecting his ability to hold himself appropriately around the children. He's inserting this very negative broken home mindset, saying my fiance is not part of our family, it's not family pictures because he's not in it, stuff like that.
But you're not objecting to the court recommendation other than you have to have a different supervisor.
Just because she,
Yes,
yes.
That's all I need. Sir, you get final comment. This is your objection.
I want to attest to the spanking thing. That night that happened, it was 3 o'clock in the morning. I had taken my daughter from Kaylee, because Kaylee was having a hard time with her. She wasn't sleeping. And effectively, I brought her downstairs where she started to cry and get upset. Kaylee comes downstairs, oh no, baby, it's going to be okay, and interfering with me as a parent and trying to overstep what I'm doing when she was already having issues to begin with. That's the full story on that one. And when she's talking about calling the cops on me, this was months prior or months before. There are 2 different instances. Sorry.
All right, a lot to unravel. Obviously, there's a court order relative to the Oakland County order. The court's not modifying that order in any way, shape, or form. Court is sent for you to do so because that. Oh, that's right. We did consolidate.
However, that custody was not a court. However, I think, and I tried to reference in my recommendation with the that we need parenting. Even though that.
Okay. So, regarding sole legal and sole physical to mom, reasonable parenting time to father. There's nothing regarding our recommendation for this heard. Father's objections to the recommendation say there's reasons for it as well. And child marks and child marks and situation. I have gotten the recommendation from the board. However, as it pertains to the supervisor, Stefan, is Steve Blue, is Jessica Bradley, or Ms. Sierra. Or absolutely, it's entirely the recommendation of the board, other than tweaking supervisor list. When it's alleged that maternal grandmother was engaging in behaviors with mother that she found appropriate, the child came back to bruises, well, the child came back to bruises, the father was sick. It wasn't perceived and places marks on the child. Copy the recommendation, the objection, I official reporter.
I am really uncomfortable with trusting Blue when you try to supervise visitation. When I originally asked her to just supervise, before I moved on to try working with that, she would leave the kids there alone.
Oh, well, and I'm going to amplify the order as well. Ms. Schultz, the supervisor must be there with the child, or children, I should say, 24/7. So I don't care if the child goes to play with friends at the soccer field, baseball field, supervisors be there all, period.
So is the one supervisor just my mother, or is it my mother and my
One of those four.
Okay.
One of those four.
All right.
And I make no bones about it. I understand your concerns, but what I've heard is the alleged behaviors for father. Father went through anger management. That's one thing. But number two is we don't have Ms. Blue here. We don't have Ms. Bradley.
Blue's here.
Well, Christine Blue is?
Yes.
Ms. Blue. Ms. Blue, did you hear everything the court stated?
I did.
Now, at the end of the day here, the court made its ruling and the court's not changing its ruling, but I want to be assured by you, first, are you willing to take on this responsibility?
Yes, I am.
Okay. Understand that responsibility includes you are supposed to be with children 24/7.
I do. Yes, I
We're
do.
not to go into facilities that you need to get rehabilitation and leave the children in vehicles.
Correct.
I'm not saying he did it or didn't do it, but I'm just saying you have to be there 24/7. And when it comes to monitoring these children, you cannot back down from anyone. You are essentially the supervisor of these children. You understand that?
I do understand that, Your Honor.
Understand penalties in the event, God forbid, something happens to that child and children on your watch.
You understand that, yes, Your Honor.
Be held in contempt for violations. And you have to be able to stand up not only to the children, but the mother and the father, and be a grandparent monitoring those children.
I understand that, yes.
And are you giving your word under oath to this court that you will not try to shirk your responsibilities as a supervisor over these children?
Yes, I give my word.
If it's a violation, bring it in. And believe me, we'll address it. Ms. Schultz.
Only thing I would like to clarify, Your Honor, because we are in second weekend of the month.
Yes, because I'm supposed to go to work when I leave here. I'm already gonna have to call off, so.
What time do you get off work?
I get off at like 11, 12 o'clock at night.
Yes, reason.
Oh. So when you get it this weekend?
I think I'm on Friday or Saturday, some point.
Rather Saturday?
I'm sorry. I had recorded proof and all sorts of proof that Christine is not a good supervisor. Their house is not in good condition right now.
My son currently sleeps.
Wait, sir, please.
Sorry.
His mom just got evicted and moved back in with him. They have several dogs. They also have the sister living there as well. There is no space for the children anymore like there once was. All of the bedding and everything that is at that house was from me. They refused to let me have it.
But wouldn't that be where the parenting time was, regardless of the show?
It was, and I will note that Mr. Blue did allow Mr. Holbrook to do a virtual home inspection earlier this year. And we didn't find any concerns.
But that has changed as of recently, so if a home inspection could be done soon, I would appreciate that. And then on top of that, what am I supposed to do about my concerns regarding how he treats the children, how Chris justifies it and makes it okay to belittle my son, embarrass him at his graduation and tell him he can't.
You're bringing this information up now, but the point I'm trying to make is I've essentially grilled this potential supervisor of what she has to do. And if she steps out of line relative to any of that, believe me, feet will be put to fire. I'm not playing games. And the last thing I want to do is send two young boys to people who are going to mistreat these children. And so I've heard the testimony, I've considered the testimony, and if you would have objected to the entire recommendation, that'd be a different story, but you did not object to it. It only came down to the supervisor. And when I heard the testimony regarding the child coming back with marks, it wasn't based upon what grandmother did, it's what father did. And grandmother now is one of the responsible parties, except including those other three that I mentioned. So we're going to try this and see how it proceeds. If there's a problem, immediately contact police or contact court or the friend of the court to file a motion. That's my rule. That'll be all. Thank you. 1:30 was the scheduled time for hearing relative to allegations of violation of personal protection order. Mr. Talisman appears by the Zoom application. He's currently lodged in the Sand Lake County Jail. He's represented this case by Attorney Michael Morosky, who is in the courtroom. People are represented by Prosecuting Attorney Timothy J. Rutkowski. First, on behalf of the court, I wish to apologize to everyone involved in this case. This matter was scheduled for 1:30. We had an extensive civil docket this morning that we anticipated would take some time, and it did take all of that, and then some. I understand people have third shifts. They work midnights. They have to come in at the last moment for hearings. No sleep. We have law enforcement officers here. We have Sand Lake County who's been gracious enough to get Mr. Talisman before the court via Zoom. We say 1:30, we try to start on time, but because of the motion hearings this morning, we could not do so. So I wish to apologize to everyone who's been inconvenienced by not having this hearing scheduled on time. I've been advised, though, that there may be a possible resolution of this case. Is that correct, counsel?
Yes, Your Honor.
And Mr. Morosky, what do you propose at this time?
Mr. Talisman will be pleading guilty to the probation violation, or the PPO violation.
All right, thank you. Mr. Talisman, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
So help me God.
Thank you. You may put your hand down, sir. Would you please state your name?
David Talisman.
And sir, do you acknowledge being served previously with a personal protection order?
Yes.
And you're aware of the conditions regarding that, is that correct?
Yes, sir. Yes, Your Honor.
Okay, thank you. And you are represented in this case by Attorney Michael Morosky, is that correct?
That is correct.
Have you had sufficient time to speak with him regarding all of this?
Yes, Your Honor.
Do you need any additional time to speak with Mr. Morosky regarding this matter?
No, Your Honor.
Is there anything, sir, that's affecting your mind or brain, making it difficult to make important decisions?
No, Your Honor.
And you have a clear mind, sir?
I believe so.
All right, if you don't believe so, would you tell me?
Yes, yes, Your Honor.
Okay. The court has been advised that there was an alleged violation of a personal protection order that was served upon the respondent previously, Mr. Talisman. Actually, there's proof of service indicating that as well. And Mr. Talisman acknowledges receipt of service and the conditions of the personal protection order. Mr. Talisman, I have to advise you, you have a right to a contested hearing in this matter where it must be shown beyond a reasonable doubt that you violated the terms of your personal protection order. You're entitled to the assistance of an attorney. Mr. Morosky is here to represent you. And at the hearing, it'd be the burden of the petitioner in this case to establish beyond a reasonable doubt that you violated the terms and conditions of your personal protection order. You understand that, sir?
Yes, Your Honor.
You are not entitled to a jury trial on this. This is considered criminal contempt. And as a result, the court would make a decision relative to whether there's a violation or not at a hearing. So it'll be essentially a bench trial or a bench hearing. You also have to be advised that the maximum sentence that you could face is up to 93 days in jail and or fines as well. You understand that, sir?
Yes, Your Honor.
Understanding all of your rights then, how do you plead to violation of the terms of your personal protection order?
Guilty.
Morosky, you wish to establish a factual basis?
Yes, Your Honor.
Gentlemen, can you see and hear me?
Yes, sir.
All right, and as Judge stated, you were served a personal protection order not to have any contact with Shauna Laviette.
Correct.
right, and it was served upon you?
Yes,
And back on Wednesday, July 3rd, you had contact with Shauna?
yes,
And this was contact, was at her home, asking her for a DVD?
correct,
And this was in violation of the PPO order, correct?
correct.
No further questions, Your Honor.
Mr. Rakowski, any questions? Can we approach on? Yes. Mr. Levelette, just to let you know, the court just took a brief sidebar with both counsel. And the question that was posed to the judge, to me, was how to proceed relative to just simple procedure. How we proceed, whether we proceed to disposition and or sentencing today, and also allowing the parties an opportunity to speak, not only you, but your attorney as well as Ms. Levelette. So is that a fair assessment of our conversation, Mr. Counsel?
Yes, sir.
And Mr. Morosky?
Yes, Your Honor.
Okay. Mr. Morosky, based upon what the court has heard, and Mr. Levelette, the court finds that indeed Mr. Talisman has violated the terms and conditions of the personal protection order beyond reasonable doubt. The court will accept his plea, he's done freely, he's voluntary, his understanding and accurate. There's a sufficient factual basis, hence the court accepts it, and we shall proceed to disposition. Mr. Morosky, is there anything you'd like to say on behalf of your client before the court imposes disposition?
Just briefly, Your Honor, they did have mutual contact with one another. Mr. Talisman understands that he's in violation of the PPO. It's against him, not against the other party. At this time, Your Honor, you ask for a just and fair sentence.
Very well. Mr. Talisman, is there anything you'd like to say, sir?
Your Honor, might I have 2 moments or 2 minutes? I need to go in the hallway for a second.
Okay, we'll take a short recess. An opportunity just briefly to step out of the courtroom, and I think we left off with Mr. Talisman. Mr. Talisman, is there anything you'd like to tell the court? You don't have to if you don't wish to.
No, Your Honor.
Well, Mr. Rakowski, on behalf of the petitioner in this case, and as I'm going to treat this essentially as a victim's rights matter where a lot of them will have the opportunity to address the court as well. However you wish to start.
Could I just ask Ms. Lala a few questions?
Go ahead. Place her oath.
That'd be fine.
Please raise your right.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Mr. Rakowski, go ahead.
Please state your name for the record, spell your last name.
Shanna Laviolette, Laviolettt.
Ms. Lala, you have a personal protection order against Mr. Talisman, correct?
Yes.
And you heard him admit that he had contact with you on July 3rd, which is, that's a Wednesday of this year. Could you explain to the court how that contact came up?
I was at a friend's house, Daniel Stevens, and
Before that, though, this would be, or I should say, later on from there.
oh, Wednesday morning. I was arriving home and I was traveling north on South Silver Street towards my house. David was in his truck in front of me. He pulled over to the side of the road and I passed him, pulled into my driveway. He walked up to my vehicle and had contact with me. He was asking for a DVD.
And you stayed in your vehicle?
I stayed in my vehicle.
And you called the police?
And called the police.
This would have been the early morning hours, correct? Like 7, 8 o'clock in the morning?
Yes.
Prior to that, the evening before, you were over at a friend's house?
Yes.
And when you were over at the friend's house, did Mr. Talisman show up there?
Yes, he did.
Can you explain to the court how it is that you knew he was there?
I believed I heard his vehicle pulling up in the driveway. My friend instructed me to go hide in the closet, and I did. There was a lot of commotion going on. There was yelling, "Where is she? Where is she?" Eventually, I did tell him where I was. He came into the closet and yelled at me. I don't know what he said, and shortly after he left.
And your friend, was he in need of medical services after he came out of the closet?
Yes, he was unconscious.
Were you concerned that Mr. Talisman would have been in your residence sometime before you were at Mr. Stevens' house to find out where you were at?
I believe he was at my residence before he came to my friend's house.
Do you have some type of app or anything that would tell where your location was on some device at your house?
I did have a iPad at my house that I believe he logged into my Snapchat and read my conversations to figure out where I was.
Do you have anything you want to tell the judge about what the potential sentence you would be asking for? I mean, it's up to the court as to the final sentence, but do you have anything that you'd like to tell the court concerning your safety or anything of that nature?
First, I just want to say I feel like David was really working on himself and we were in contact a lot. I was ready to drop the PPO soon. I was this is just really hurtful. I don't want to be in this position.
Do you have some concerns, Ms. Lavalette, because of your petition and alleged physical and mental abuse for a period of time as well?
Yes, I'm concerned.
You still remain concerned today?
Yeah.
Anything else you want to tell the judge? Just on behalf of people, the reason we asked a few of those questions in this level was wanting the court to know that this isn't just some passing contact. This was something more entailed, and as a result, should involve a sentence that would reflect as much. So on behalf of people, I mean, we would ask for the court to consider the 92 days.
Very well. I'm going to allow Mr. Mosky to question. Sure. Petitioner as well. Mr. Mosky, you have a question?
Just briefly, so at some point you and Calvin were having mutual contact?
Yes.
No further question, John.
Any rebuttal arguments to the request by the people relative to this position?
Your Honor, we would just ask for a just and fair sentence here. Thank you.
Very well. When was he lodged on this? Anyone know?
I would assume that because there's an aggravated stalking complaint that would have taken place on July 3rd. So he's been lodged since July 3rd.
Was this in the morning or evening or after?
Morning.
Morning. Mr. Talisman, you were in Sand Lake. Actually, I asked Mr. Morosky. Mr. Morosky, why is he in Sand Lake?
Your Honor, it's my understanding that there is pending criminal charges in San Luis County.
No charge is?
I believe it is. There's a home invasion charge. That's all that I'm aware of.
Home invasion first.
Anything regarding this individual petitioner?
This is the incident that the petitioner described, where she was at the residence of her friend.
And that was in Sand Lake?
Yes, it's just inside Sand Lake County by 3/4 of a mile.
Yes. Okay. Mr. Talisman, we take personal protection orders very seriously. We have to. And certainly I can understand at times when individuals may decide to reconsider their decision in filing a personal protection order or thinking about, well, geez, maybe we can make things work. Maybe you need to work on yourself or the other person needs to work on themselves to eventually get to a point where maybe things can be changed. Maybe we can get rid of personal protection orders in certain cases and allow basically interaction to continue in a lawful manner. I'm not passing any judgment on the charges contained in, or that I've heard of in Sand Lake County. That's up for someone else to decide. My concern is whether or not you violated the terms of your personal protection order. There's no question in my mind you did. And when I consider that, and because I read the initial petition for personal protection order, and when I read it, it was troubling. It frankly was, and that's why the court authorized the personal protection order to begin with. It expires April of next year. As a matter of fact, April 14th of next year. As a result of this matter, the court is going to sentence you to serve 60 days in the county jail, credit for 9 days previously served. At this point in time, you're under sentence to this court for the PPO violation. If you remain in Sand Lake County, that time while you're on bond will be credited to this. But I have to assure you, Mr. Plants, you come back, I'm sorry, Mr. Talisman, you come before the court again on another PPO violation, it's going to be the maximum. If not, because we don't play games with this. And you know, we may be tempted. There may be someone out there that says, oh, look, she wants to have contact with you, or he wants to have contact with you. When you have a piece of paper that says no contact means just that. You understand?
Yes, Your Honor.
All right. Thank you, everyone. Thank you to the deputy and the officer who appeared in Sand Lake County as well for bringing the respondent here. That'll conclude the proceedings.